to get going, I want you all to know that we are live streaming this. We do have audio, video in the back. Please hold your questions until either Samantha or I get to you with a microphone. We know that everyone in the room can hear, but we want our people who are on the live stream to be able to hear as well. So I don't know that we need to introduce Jamie. You know, it's him, it's Jamie. And then so we have our legal counsel, Jamie Bowditch. We also have Mike Nugent, who is our forms subcommittee chairperson from the Missoula Organization of Realtors, and Angela Klein-Hughes, who is our first vice president out of the Billings Association of Realtors.
That's not correct.
President-elect, sorry. It's been a day and it's only 11:30. She's one of the people on the leadership team that I report to, so I probably should get her title correctly. Anyway, at this point, I will get off the stage and turn it over to your panels.
All right, thanks, Karen. Yeah, Jamie Bowditch, for those that I have not met yet. Seem loud new faces around here, which is excellent. You know, and maybe just to kind of set a really quick background. So, you know, we've had a pretty busy time of making some form changes. The most significant ones went into effect just prior to the August 17th NAR practice change date. And then what happened is, you know, since the practice changes have gone into effect, and, you know, who knows what's going to happen as of January 20th, but, you know, with new administration and a new head of the Department of Justice Antitrust Division, but at least prior to that, the Department of Justice had not given up in looking into certain aspects of the realtor business. You probably already heard that the appeal to the Supreme Court, the U.S. Supreme Court, by the realtors on the settlement agreement with the Department of Justice, they decided not to hear that. So that decision from the lower circuit court stands. But, you know, one of the things that we were hearing loud and clear from NAR and legal counsel from around the country, especially NAR Legal, was, you know, one of the items, notwithstanding these practice changes that are now fully incorporated into our forms, we need to do a better job, we collectively throughout the country, of making certain that we're transparent in exactly what's going on, especially as to compensation, that their choices are being made clearly, and that the buyers and sellers are, you know, fully understanding what they're getting into when they're signing representation agreements like the BRAs and listing contracts we have. So that's kind of the theme, or the kind of, I guess, the 30,000-foot level of some of the form changes that are going live. And as a reminder, the go live date is Monday. I did receive a confirmation this morning from the last form vendor that that will occur. And you know, I hope I don't have to provide this, but I'm going to, just to make certain everybody knows that, you know, there's a couple of things in the practice changes that are driving these forms that come out of the settlement agreement. One is, you know, there's obviously no compensation on the MLS. We all know that prohibition. But, you know, in addition to that, you know, in the buyer representation agreements, you cannot have what we used to have in a short form agreement that basically said, I, as a buyer agent, am going to be paid whatever the listing agent or seller is willing to pay me. That is no longer permissible. So we can't have that, and that's driving, obviously, a lot of the changes to the BRAs. And then, you know, as the BRA, you cannot have compensation that you receive for services provided that are greater than what you agreed to in your buyer representation agreement. So if your BRA says 2 apples and the seller offering compensation is willing to pay 3 apples, you're going to get 2 apples, notwithstanding that they may have agreed to pay you more. So I think everybody knows that, but just a general reminder to kind of kick the show off. Michael.
Yeah, and I would just add to that, you know, the Forms Committee exists first and foremost to benefit you. That means that we want to keep you out of legal trouble as best we can, and also protect you. And, you know, in the Power Hour last week, there were a lot of questions in the chat, and I feel like some of you might have learned about the NAR settlement last week, but hopefully we're making some progress here. You're all laughing because you can think of someone in your association that might be true. But I say that because the Forms Committee did set out to change the forms to make your life more difficult. And yes, some of this is more complicated than it used to be, but that's the result of these settlements that NAR has entered into. as well as some of the other lawsuits that are working their way through the courts right now that Jamie and, NAR legal counsel across the country are paying close attention to. So I want you to kind of keep in mind that some of the things that would make sense, we probably agree with you on, but the settlement terms say we can't do it. One of those is like a range on the buyer rep. You cannot have a range of commission on a buyer rep form. So, and I guess last thing I want to say is, if you're on the forms committee, would you raise your hand? So if you have an idea for a form, you can always reach out to someone on the forms committee and let them know, and they can put up the chain. There's also, if you go to the MAR website and log in, there's a form submittal form somewhere in there. And that gets to us, and it goes to a screening panel to see if it's something that needs to go to the full committee. And Angela likes us to be on task, so I want to make sure we're following it.
He's on task. I think what we're going to do for purposes to be less chaotic is we're going to get through the forms, okay? So we want, please allow us to get through what we're talking, and then we can ask questions. We are going to move things along quickly, all right? We do not have the time to take on loads and loads of questions. If you have questions, again, members of the forms committee, please raise your hands. Look around right now at the hands raised. These are the members you can also go to, all right? So with that, we are going to start off with the buy-sell agreement. Here we go, we're kicking. So, I'm going to start with one of the more simpler forms changes on the buy-sell agreement. It's more for the forms committee thought clarification and purposes that just make sense. Under the inspection contingency, you're going to receive new language in the inspection contingency. The language has to do with a buyer submitting an inspection notice prior to that notice date. So again, the notice date is the first date under the inspection contingency. What the forms committee clarified and actually created a new addendum, it states essentially that the buyer has the right to withdraw and terminate their notice anytime prior to that notice date or prior to seller's acceptance, all right? We did create an addendum then in which the buyer can submit a withdraw and terminate. This is not to be confused with the form of the withdrawing of the inspection contingency, which is vastly different. That addendum withdraws and tells you you're moving forward. You're releasing the contingency. So I think Jamie did a really good job of clarifying the titles on those addendums. So it will be very difficult for us to mix those two up, as again, they serve two different purposes. So again, the buyer has the right, again, to submit prior to that notice date and prior to seller's acceptance on a notice, a withdraw and terminate. All right, so that is one, and that has been something that has been wanting clarification for some time, and I think the Forms Committee did a very good job on implementing that forms change.
And maybe just to drill down just a slight bit, so the inspection notice, right, that you all use right now is been modified under the checkbox of termination to allow for the termination not to be the first time, but if it follows a prior inspection notice where you've noted conditions or you've requested a rebate or a discount in the purchase price of some kind. So what you use is, like, for example, send out an inspection notice and you say, prior to the notice date again, send out inspection notice, say I want a $10,000 discount, and then in doing some more due diligence, maybe you realize, nope, this is not the house for me, or this is your client. And so as long as a notice date hasn't passed, one, and two, the seller has not accepted the inspection notice you sent over previously, then you can withdraw what your previous inspection notice said, go to termination by using a second inspection contingency, and this time checking the box that says termination. And then on the withdrawal notice, as Angela exactly said, is that's been clarified so that it isn't accidentally used to withdraw an inspection notice and terminate, but it's been clarified to clearly laying out that the withdrawal is limited to situations where you're withdrawing an inspection notice by a buyer and going forward with the transaction, thereby releasing all inspection contingencies. And one overall thing I'll say, and one of the reasons that MAR released the forms or samples of the forms back 2 weeks ago now was that, you know, before they go live on Monday, if you haven't already done so, look at them, right? Read them a couple of times. Make sure you understand them so that when you go to use them on Monday, Tuesday, Wednesday next week, you're understanding them and can adequately explain them to your clients.
And I would just add to that, when you are, you know, back in your associations, back in your offices, and you're talking to other agents about sitting through this or what you learned, so many of the mistakes that I think Jamie gets calls about at the legal hotline could be prevented if agents just slow down and read the form, even if you think you know it, because people often think that it says something it doesn't. So we'll get questions to be like, well, the forms committee should do this. And it's like, well, I've got news for you. We did that 7 years ago. It's actually on the form. So that sort of stuff happens.
Moving on with the buy-sell, again, we're going to try to move swiftly. We added a couple additional addendums under the addenda checkboxes, one of which I will speak of. I think Mike may speak on the other one. We added a solar panel addendum. Yes, I do admit this is the baby I brought forward. I had my first transaction with solar panels this year, and I actually purchased solar panels for my own home this year. So after realizing all the nuances that are involved with solar panels, I truly felt it was necessary that we then try to move forward an addendum regarding solar panels. And I think Jamie did a very good job on the creation of the solar panels. How many of you, by a raise of hands, have done a transaction with solar panels? Okay, so would it have been nice to have this form? Yes. This form deals with leases. It deals with if there's a lien against those solar panels. It also addresses warranties with solar panels. I think Jamie did a very good job as far as covering everything that we could possibly think of, that we know of, that pertain to solar panels. So with them becoming more and more relevant, I feel this addendum will help protect both buyer and seller when they're purchasing and transferring the solar panels with the home. The other addendum we added, we'll go over questions once we get through this, but the other addendum we added was the compensation addendum. Michael, would you like to speak on that?
Certainly. So one of the topics forums has been dealing with since the settlement came to be was, first of all, kind of the culture shift of you can negotiate commission on a buy-sell, and a lot of people have been on the impression you could not do that. Some states have added it right into the document. Other states have taken the addendum approach, which is, after a lot of conversation, that's the route that our committee has decided to go, because this form actually can do a lot of different things. It can be used if the amount a seller is willing, or a buyer's or a seller's agent's willing to cooperate, is less than what you've agreed your buyer will pay, and your buyer wants you to try and negotiate for more. It can be used if you are an agent who's changed their business practice to not do cooperation of any sort, so that the commission comes straight from the seller. And so we tried to create a form that allowed for the possibility of several different business practices. And the flexibility to kind of build that into not only this form, but we see it a little bit in how the listing agreement's broken down as well, arises from a lot of things. Well, I mean, there are different interpretations from different lawyers in different franchises. There are different states that are doing it different ways. And we want to create space for you to do the business practice that fits. I think that touches that.
Well, and we were instructed by the immediate past president to have more checkboxes.
Yes, yes. DJ Smith, checkbox king.
The only thing I would add is another thing the Forms Committee brought up with an addendum. Every agent then, if we are requesting seller direct compensation or additional compensation, they're using the same language. Instead of writing your own or trying to create your own language within the buy-sell agreement, this addendum will make it universal where we're all using the same language so we can understand. As when we create language, it can be open for interpretation sometimes.
Yep, and, obviously there are, if you work for a franchise that has other documents that they want you to use, that's perfectly legal, and I think that it's important for everybody to kind of hear and understand, but that doesn't necessarily mean that the other party has to use those. So sometimes that's part of the negotiation, and that's why we tried to create forms that could create some flexibility and make sure that we can meet those various business practices. But these ones have been reviewed by our legal counsel.
Yeah, and Mike's got an excellent point there, as is Angela's. Again, back to the theme, what do we have to be doing? Well, we have to make certain that we're maximizing flexibility and consumer choice. And so, one of the reasons you're seeing, in all honesty, and not to be funny, more check boxes is to kind of create that opportunity for consumers to make choices, and for you, obviously, as their representatives, to make certain you're explaining those choices in clear detail.
The only other change on the buy-sell is there's, there's some new check boxes. As we just got done identifying that, just indicating buyer is not represented by a real estate agent or seller is not represented by a real estate agent. So those are on lines 547 and 550. Make sure you review those in the event that you're in a transaction with an unrepresented buyer or seller.
And maybe, sorry, Mike.
You're good.
It just is a quick reminder, because this question does come up, because people now see these check boxes, and they're like, well, isn't there some type of form that I can use to have the buyer acknowledge when they're not being represented that I'm not representing them? Yeah, there is. It just went into effect, 6 months ago. So it's unrepresented buyer disclosure and acknowledgement, I think is the name of the form, but it's out there. And so, as we see more unrepresented buyers, as I think probably is happening, maybe not as strongly as some people thought it would, that's a form that can be used in addition to checking the appropriate box in the buy-sell agreement now.
Yep. And that form is one that I think protects a lot of people, but it's important. Sometimes we kind of get in this tunnel of like, this is the one thing we should do. A buyer doesn't have to sign that form, but if you as the listing agent are working with a buyer who's representing themselves, even if you present that form and you've got an email kind of saying like, hey, review this, and then that box is checked in a buy-sell, like you're a lot better off than you were previously. And I think we're making that clear. And the other thing that I just kind of want to stress is it is okay for that buyer to be unrepresented. Don't shift yourself to dual agency unless that's actually what makes sense in your transaction. And there's no need to try and do you're representing the seller and then you're trying to be a statutory on the other, because that doesn't even make sense. You can't. Yeah, exactly. And people kind of find these ways to do things that they're not legally allowed to do. So use the little hotline, ask questions.
One more change that I'll have Mike hit on real fast as well is we put some more meat into the Foreign Investor Real Property Tax Act of 1980, also known as FIRPTA. And so lines 434 through 443 of the buy-sell has to do with the Foreign Investor Real Property Tax Act. I'm going to have Jamie explain exactly what that tax act says, and then we can have Mike go into the actual disclosure form.
So before Jamie talks, I want to put a big flashing sign in your minds that this is one of those moments where the Forms Committee did not come up with something that's going to confuse the hell out of you. This is actually some federal regulation that Jamie is right, that we need to make sure that people are protected on. And so we're trying to not only create an environment where we're addressing what's there now, but as a Forms Committee, we're going to try and see how other states are doing this to see if there's a better way.
Yeah, and I think most of you have heard of FIRPTA, but it basically, I think the reason it's become more prominent and prevalent is because, the threshold to get over when FIRPTA stuff is required is $300,000. So you got very few transactions happen now, at least with any structure on them, that are under $300,000. And so FIRPTA requires, or doesn't really, well, what FIRPTA says is that if you have a foreign seller and you don't withhold money, then the buyer may be obligated to pay the withholding tax, which can be 10% of the purchase price. What you want to have in your file, or you want the buyer to know, is that the seller is not a foreign person, so that whole withholding doesn't apply. That's what the statement is for. Language out of the buy-sell agreement just kind of beefs up the requirement that a seller provide a FIRPTA affidavit if they don't want to have money withheld from their purchase price. In 99.9% of all transactions you're involved in, except for maybe, you know, people up in the Flathead where you've got some Canadians, you're not going to have a FIRPTA, you're not going to have a foreign citizen, but you still need this because you don't know. And so one of the things that's troubling is the requirement under federal tax law is that the FIRPTA statement of non-foreign status, you see up on the screen here, does require the seller's tax identification number, social security number. And so what you know, Mike wants me to go to the executive branch of the federal government and fix this. Well,
No, I'm going to do it for you.
yeah, okay. But it's been around for quite a number of years. I do think the $300,000 has not been indexed up for any type of increase in the housing market for many, many years. But the point is this, you know, this is a document which requires some pretty sensitive information. What's the solution? Solution is a couple. One is, don't do it, not a good solution, but an option. Number two is, you can have what's called a qualified substitute. So maybe the best thing to do is to provide this to your seller client if the buyer is requiring it, and the buyer should, and have the seller fill it out, and just have the seller either hand deliver it or upload via secure portal, whatever the case may be, it to the closing agent. Never gets into your file, doesn't need to be in your file. Closing agent has it and can verify that the seller's not a foreign citizen for which the withholding applies. That way, and we all know that, you know, the closing agents already have sensitive financial information, tax identification numbers, SSNs. So that's probably the best way to do it, just because I would recommend that you not have this filled out by you and saved to your system for obvious reasons.
Yeah. And the reason that we're all talking about this is federal law, I guess it's from the executive branch, basically says that if the buyer buys a house from a foreign entity, foreign person or entity, and that foreign person or entity does not report it and pay the appropriate tax, the buyer has financial responsibility. And Leanne's shaking her head, and I'm right there with her, which is why we're gonna find a way to change this. But in the meantime, I know. But in the meantime, this is a real thing that agents need to be aware of. And that $300,000 threshold is, what, 70% of all of our transactions probably in the state of Montana? So we're going to look and see if there's a way to incorporate some questions into the listing agreement, maybe that kind of would prompt the question to be asked. But if you're not comfortable having a seller fill something out and put their social security number on it and give it to you, and I'm not, you know, what Jamie was saying, work with your title company, that's where I think it's really important for all of us to, you know, make friends with our partners in this business. And when you turn in a transaction, the title company, put it on their radar. Say, will you ask the seller to fill this out? Or can, you know, there are ways that you can do this and we can achieve this without you having to collect that. Worst case, you could have your seller fill out that form and leave that part blank and give it to the title company and say, hey, if this applies, will you have them finish this at closing? So there are ways to work around, but it is a requirement under federal law. So as much as I want to joke about, I'm not going to say storming the federal government, that's dangerous, you know, too soon. It's a problem, and it's something we need to be aware of.
And just know, we did speak about this for probably 45 minutes on this form, prepping for this. And we acknowledge, we share the same concerns you probably are bringing forward. That is sensitive information. How are we going to handle this? As Mike, I just want to reiterate so everybody heard it, we are looking for a better method to see if there's a better method. This is what we have for right now.
Yeah, but in the meantime, this is the law. So comply or call Jamie.
Buyer rep.
Is that what we want to go to? Sure. All right, so there are, you know, the number of buyer reps we have just keeps going up. But what is happening here is, and we said this right from the beginning, that we would try and be responsive with the buyer rep agreements to how people are doing their business practices. So the first one that I just want to touch on quickly is the limited services buyer rep agreement, the touring or showing agreement, which we made some adjustments to, but this form is the general idea hasn't changed since we first released it, which is essentially you are signing this agreement with a client and saying you'll show them a handful of properties, and that is it, and there's no charge associated with it, and you're kind of laying that out. And that meets the terms of the settlement because it basically is premised on if you do something further for that client, like if you're going to write an offer, you need to get a more formal buyer rep agreement signed.
You don't need to, but you're not going to get paid.
Yeah, you're not going to get paid. And on that note, if you think you're going to get paid because you signed a cooperation agreement but you don't have a buyer rep signed, you are violating the terms of the settlement. And there are lots of different ways that could be a problem. So we've had questions, and I know Angela, goes around and teaches, where you might have a buyer rep that says you're getting paid X apples, and then there's a cooperation agreement that says you can get paid X plus 5 apples. Well, unless that buyer rep says you can get paid X plus 5 apples, you cannot get paid. And NAR has said you can amend it, but Jamie doesn't, yeah, Jay, I was going to say.
They're softening their stance on that is how I'll put it.
Yeah.
Not recommended to amend the buyer rep agreement simply to capture additional comp that may be offered on the seller side without some other justification for increasing the compensation that you had agreed to when you signed the BRA. I think it's a troublesome thing that I would not recommend that anybody do. And I think NAR is kind of backing, I don't want to say backing down, that's what they're saying. It's just, there better be good reasons for increasing your comp other than, well, the seller's offering more money.
Yeah, essentially you have to prove your worth of why your fee went up. I mean, look at it that way. That's one way of looking at it.
Or I was giving you a discount because you couldn't afford it, but now we could debate that on a whole nother setting. The reason I bring it up is because that kind of flows right into the newer buyer rep form that we've added in here, which is a buyer representation agreement for seller paid compensation. And before I let Jamie talk about this one, we had questions in the power hour why we did not make this form basically universal, in that you could just sign this as a blank, I meet a client, I'll take whatever the seller might offer. And first of all, it does not meet the terms of the settlement because it does not specifically identify what your fees are. But the other problem there is if you did something like that where it was just a blanket, I'll take whatever the seller is offering, and the seller is offering 0, you are still obligated to represent them if you sign an agreement like that. So you have just committed to working for free. So when we talk about one of the things the Forms Committee tries to do is tries to protect you, that's what we're talking about. And don't get me wrong, if working for free is your business practice, that is perfectly fine. I know we're being recorded, so people do that sometimes, but I'm just saying you need to be aware of it. Am I making you nervous yet?
No,
All right.
you do. Not yet. You will. And I think, I will be brutally honest here. I was very reluctant to adopt a form like this because it makes me nervous. But I do think it has its place, and I think there are situations where it can work, and I'm kind of coming around to it. But what this form is really designed to do is to address situations where, and I said this in the cover email that went out with the forms a couple of weeks ago, you've got to have, and you absolutely positively have to have these conditions met to be signing this agreement. Number one is you have identified, you and your buyer have identified a property or properties where that the seller or seller agent is paying compensation. And number two, either the amount of that compensation or the mechanism by which that compensation can be calculated. In other words, a percentage or a flat dollar amount. But if you don't have, because you can't have as Mike just alluded to, you cannot have a buyer representation agreement because it is expressly prohibited verbatim by the terms of the settlement that says I'm going to be paid whatever the seller's offering. So you have to know that what the seller's offering and that they're offering compensation in order to use this form. And so I can see situations, Mike and Angela were talking about this before we started here, where you've got a buyer who knows there's absolute no way they're going to be able to afford to pay you. And so you sign a touring agreement to go look at some homes. In the course of looking at, let's say, 10 homes, they find 4 that they like, and of those 4, 3 of them are offering compensation pursuant to conversations you've had with the listing agreement or information that's been provided to you, like in social media. Okay, then you can switch from the touring agreement, sign this buyer representation agreement for seller comp, and focus on those three properties, as long as you're listing in the buyer representation agreement what the compensation is. And that satisfies the terms of the settlement. Whether or not that'll be the new business practice, I don't know, but I can see that being used more frequently with situations where a buyer is just adamantly unable to pay you compensation and tells you that up front.
Yep. And the reason, it makes us anxious, because like being people who like forms, we like specifics, especially Angela. There are now several different ways that you can legally comply. And it is on agents and their brokers to really kind of make sure that we understand what the business practice we're doing means, that our clients understand it, and that everything's being communicated. And oh, by the way, just to stress this out, if you sign a buyer rep agreement, say I sign the touring agreement, and that's the only form I sign, and I go out and show houses, am I susceptible to a Board of Realty Regulation complaint?
Be more specific.
If I only sign a buyer rep agreement with someone, I just met you today, and I sign a buyer rep agreement and nothing else, yes, relationships in real estate has to be signed before you do anything. And yes, somebody just said it says it right on the form. That's why you got to read them, right? All right, let's switch to the actual, the buyer rep agreement.
The main
The
buyer.
main one, yep, because
Which one of you want to take that on, Mike?
Jamie, you want to start and I'll jump in?
Sure. Yeah, so there are not a lot of changes to this agreement on a substantive basis, as we indicated earlier. The intent here was to kind of break out sections, especially the important section that has created a lot of heartburn over the course of the past 18 months, which is compensation. And so, what you'll see here, as I'm showing, is, you've got this compensation agreement section. We also, if you remember the old BRA, the long form, compensation was kind of, I don't say buried, but back towards page 3 or 4. We moved it up front and center right after the disclosure section. So, when you're reviewing this and going over with your buyer, you're going to want to make certain you can explain the choices that are available as far as the compensation. You got a checkbox here at line 36 that says, you're authorized to negotiate and try to obtain payment. There's the retainer fee, which has always been a function of our BRA, but I don't know how much it's been used. And then just the information about the kind of a disclosure, if you will, that there may be seller paid compensation. So, I know it looks different than it did a couple of days ago or a couple of weeks ago before we released this, but it really isn't substantively different than the compensation agreement before, other than a couple of things to mention that I think are actually kind of interesting ideas that were member requests brought forward to the forum subcommittee, and that's this authorization section, where you've got 2 authorizations, one going one way and one going the other way. First one under sub A is the authorization from the buyer to the buyer agent to utilize the services of other agents, licensed assistants affiliated with that buyer agent for situations like, for example, you might have 3 or 4 licensed assistants who do the touring on your behalf, and when a buyer is ready to make an offer, you kind of step in and take over. That would provide the authorization for that. And then you might have situations on the other side, right, where a buyer's, moving here from Vermont and they have a daughter here and they want their daughter to go around and look at homes with you. You got to have a representation agreement signed before you tour homes. So B would be for a situation where the person moving from Vermont could designate their daughter to tour homes with you to find homes that he or she may want to buy before they move, and you put the names in there at lines 111 and 112. So I think some really good ideas that were brought forward by members, which is why, as Mike said and Angela said earlier, if you've got some ideas, we're always open to suggestions. In fact, I would say, other than over the course of the past 18 months, about 95% of the form changes we make come from the membership. And obviously the NAR practice changes came from somebody else.
Can I change it? So, I mean, one of the most common questions I think that we've heard at panels you've done and in classes, if I sign a buyer rep with someone and then I go out of town and I want someone in my office to show property for me, those authorizations are specifically for that situation. Somebody asked if that person that I'm going to have cover for me is with a different brokerage. My advice there would be to have a new document signed, but there's probably some.
Yeah, I think that, I think, I don't want to get too far into the weeds on this because we're trying to approach this at a high level and leave room for questions. But I would agree with Mike on that. If you're going to turn over, if you're a single person and you're going to be gone for a couple of weeks, you want to turn over representation to a broker or agent outside of your office, not affiliated with you. I think a new agreement for the benefit of that person is probably a good idea, and you can put into the additional provisions just kind of what exactly is going on. And I would say that I'm not so sure the authorization, it really wasn't designed. I know there's some members here who work in teams, either on the seller or buyer side or both. I'm not really sure that's what this is designed for. I wouldn't use it in that situation. But rather it's for those situations where a licensed assistant or another agent affiliated with your office is either going to do work for you on a limited basis or a part-time basis. If it's a team, then I think it's better to list them out and have both people listed as the buyer reps in the buyer representation agreement as a team.
All right, real quick, we'll do an easy one first before we get into the listing agreement on this, which is the cooperating broker compensation agreement. We did make a few changes to this particular form. We did listen to you. One of the biggest recommendations we had from you, the members, is please, why do we have to put the buyers' names on there? There was a lot of questions on confidentiality where they thought that the buyer did not want they didn't want the listing agent to know they were looking. The other thing that was troublesome, I mean, I can't believe we were hearing this, but I guess in some associations, the listing agents would see the name and then potentially know that buyer and poach them? I don't know. But nonetheless, the buyer's name has been removed from the cooperating broker compensation agreement. The other big thing that you'll notice is the supervising broker signature is also been removed from this particular document. I know the supervising broker signature was causing some heartache in many different avenues, whether it was timeliness of signing, whether it was actually needed on this document. That has been removed. Mike, Jamie, any additional changes on that one that were significant besides those two?
No, I think, it was kind of A and B prong, but as Angela said, we removed the buyer's name for the reasons noted. And then to make certain that there is still the ability mechanically to tie your entitlement to a commission to something, right? Because you don't name the buyer, so it's not like you can say, that you have to have, it's kind of a procuring cause argument. You can see the language that I highlighted here. And where does it say that you're representing the buyer of the successful transaction as indicated in the purchase agreement? I mean, that's going to be the case anyways, but that's, if you're the agent paying the compensation, that's what you would look at is like, okay, I agreed, I signed this CBCA with Mike. Now I'm going to look at the buy-sell agreement and make certain Mike is representing Angela as the buyer in this transaction. Yep, both boxes checked, Mike's entitled to the money.
Jamie, let's hit on the listing agreement.
We saved the fun one for you.
Yeah, right. Well, so, kind of the same, right? The listing agreement had maybe a few more substantive changes than the buyer representation agreement. But by substantive, I mean, back to what I said earlier, really providing greater choice amongst the compensation that a seller can agree to as part of their representation. And one of the most significant changes substantively is breaking apart the compensation payable by the seller to the listing agent from any compensation that the seller is agreeable to either, or is authorizing the listing agent to pay to a buyer agent, kind of the historical model, or the compensation that a seller may be willing to pay directly to a buyer agent, or maybe even to a buyer as reimbursement. So if we just kind of, and so, you know, when you're sitting, and again, this is a form that I think it's gonna all look familiar if you read it, but it looks a little bit different from a structural standpoint. It is imperative that, you know, before sitting down for a listing presentation, you've taken a look at it and maybe even walked through it with a colleague. But you'll see here on line 31, well, that's the compensation payable to you, and that's what you'd fill in that one. We have the retainer agreement language if that's something that you wanted to collect, although not very typical. Then on line 47, additional compensation payable to you as the seller agent if the buyer is unrepresented. That's a lot more work when you've got unrepresented buyers, and the compensation you're agreeable to accept from the seller with full representation on the buyer side may be different than if there's no representation on the buyer side. So that would be, you know, this would be in addition to, right, the compensation up here. And then we break it down into the buyer agent compensation, for which there are a couple different options. Option number one is the authorization to you as a listing agent to pay compensation as we have historically done, except of course you can't advertise in the MLS. That's in line 62 to 90. Well, there are situations in business models and choices, and good choices, right, that where people, agents or companies are simply uncomfortable paying or receiving agent-to-agent compensation. And so lines 91 to 104 would be that situation, right? That's where a seller, instead of authorizing you as their agent to offer and pay compensation to somebody representing a buyer, the seller is going to do so directly. Perhaps it's in the buy-sell agreement with the seller-agent seller compensation addendum that we just created. There may be a form where it's a direct payment form that MAR doesn't have, but maybe some offices do. So that's an option, and then of course there's the option that existed previously, which is the seller's not willing to pay and does not authorize you to advertise any buyer agent compensation at all. Typically, and I think one of the things that I don't yet know how these forms are going to come out as far as what they call the radio buttons, the checkboxes, and whether they're going to be one or the other, and we may have to work through that, and we may work through that as a next form change. But typically, right, you're going to have seller agent compensation. Hopefully you guys are not working for free. And then on the additional or the buyer agent compensation, and I'm just going to, I don't know if I can, I'm going to try, well, I won't try to make it like, hold on. I know that's small, well, it's not even going to work anyways. But in the buyer agent compensation, you're probably going to check either this box that either this box right here or this box. Typically, you're not going to check both, right? Because the seller's either going to agree to authorize you to pay a buyer agent, again, the historical model, or they're going to do so on their own. So I mean, I can't imagine a situation where you'd want to check both this box on line 62, I'm sorry, and the box on line 91. I mean, maybe I haven't kind of drilled down on this entirely to figure out that situation. I'm sure there's some of you smarter than me in this room who could say, oh yeah, Jamie, there's circumstances, maybe we'll talk about them. But that's kind of how this is going to break down. And I think, one of the things that has been brought up already, which I think is a good idea and probably will be considered by the Forum Subcommittee in our next meeting in May, is another line probably down here that's like, okay, here's the total compensation that you're agreeable to pay. Just so it's specifically delineated in the listing agreement. I think it's a really good idea. I'm not sure what it'll look like. We have to talk through it, but I mean that's the big changes here in the listing contract, is just breaking down piece by piece, option by option, checkbox by checkbox, the various alternatives available to a seller as far as how they're going to treat compensation in a real estate transaction.
Yeah, and transparency is the big word there, and it's just making it as clear as can be, because the premise of at least one of the lawsuits out there is like sellers saying they didn't understand how the commission worked, and so we're trying to make it as clear as possible.
They didn't know that they were paying a buyer. I mean, that was
Yeah.
one of the claims at the trial back in October of last year.
Yeah, and so we're just trying to make it clear how it breaks down.
Okay, moving forward, I'm going to circle back to the buyer agreement. One change that we forgot to mention that was more of housekeeping was, if you recall, you have an expiration date on a buyer agreement. I don't have it pulled up in front of me, so I'm going off the top of my head of memory. But, and Jamie, please correct me if I misspeak. We had an expiration date for it, and we also had additional days built in there. And there was language, well, the complaint was, what if you put like 6 months beyond this expiration, and then there was no out? So we added the same language that was in the listing agreement that essentially says that if you enter into another contract with another broker, then those additional days no longer apply, just like in the listing agreement. Just to clarify that, that's
Yeah, I've got
correct?
it. Yeah, I've got it highlighted here, which is a little bit weird. So, you know, a buyer representation agreement, again, the long form, has always had a protection period in it, very similar, if not identical, to listing contract. But what it didn't have is the out if the buyer signed a new buyer representation agreement during the protection period. That language has been added.
And then briefly, I would like Jamie just to hit on, just briefly, Jamie, and then we'll open it up for questions. Some of the other forms that, the letter of intent for lease, relationship forms, the minor changes that we added to those.
Yeah, I mean, you know, there's now a letter of intent for lease. So if you've got a primarily commercial real estate transaction, and you want to kind of, and I do a lot of commercial leases, and it's always nice to get these letters of intent from the real estate agents, because it basically lines out exactly what the terms are, and I can kind of fold it into my documents or what I'm drafting. But that's exactly what this is designed to do, to pick up the substantive terms that the parties agree to in a commercial lease transaction, so that you can then plug it into a form or provide it to an attorney if the parties want an attorney to draft the commercial lease. In addition to that, the relationships in real estate transactions, there are now 2 of them. One's in the purchase and sale transaction, and there's been one that's been modified, and by modified I mean really simply changing seller to landlord and buyer to tenant, so that you can use it in a lease transaction, commercial or residential. The buyer agents, members I should say, were I would say complaining, but mentioning that in presenting these relationship forms to their clients, there was a lot of pushback, because they're like, I'm not buying anything, or I'm not selling anything. So those are 2 new forms that have been added that are for use. And the one thing, by the way, as long as I've got the microphone, that I just want to mention, oh crap, I closed out of it, in the listing contract, was we added some language there's an indemnification to hold harmless section that's been in there for a while, you know, basically holding you harmless, like if somebody trips and falls because there's a hole in the floor, that, you know, that's not your liability. We added language in the indemnification section where, and this is where the seller would indemnify you as the listing agent and hold you harmless as the listing agent for claims asserted against you related to, you know, not providing, misrepresenting the condition of the property, or more importantly, not disclosing an adverse material fact. We'll see, you know, once these things go live and a lawsuit is filed, we'll see how well these hold up. But I will be, you know, I want, you know, if any of you, God forbid, in the room get a lawsuit filed against you as a seller agent because an adverse material fact wasn't disclosed, and you didn't know about it, and there's some evidence that the seller knew about it but didn't tell you, you know, you're going to want to gravitate to this language and basically tell the counsel representing you to do what they call a tender of defense. Basically tender the defense of the claim over to the seller and say, I'm in this suit because of you, defend me. And that'll give you that tool to do so. Hopefully that doesn't happen very often, but we thought it was a good idea.
Okay, I think we did a very brief overview, the best we can due to time limitations. We wanted to spend the remaining time answering questions. I'm not staff. Okay, so Julie's got, and Julie and Nicole have the microphone. We ask, raise your hand, wait for a staff member to come with you to mic because we are live streaming. Thank you.
I hate to be the first one talking because I like to ask questions and everyone knows that, but I'm not bringing this here and I want to come across as constructive criticism because I value the Forms Committee, I value Jamie, but I'm going to be honest in what I'm hearing and honest how I feel. I feel that the changes to the listing agreement, I feel they work against us as agents. I feel they're too complex for the average agent. They're going to be hard for supervising brokers to teach their agents. The average agent does, what, 2 to 3 transactions a year? I feel that for you understand it. Jamie, you're an attorney, you're on forms, you teach classes. The average person, it's pretty complex. And to get into the weeds about a non-represented buyer, I get it where we have to be transparent, but I think a lot of people think that we're so transparent we have radiation burns with this listing agreement. And I'm not being smart. I just feel it's true, but
Is there a question here? I don't mean to.
No, I'm
mean-
gonna,
Yeah.
so I feel that the part about the non-represented buyer, a non-represented buyer has been forever, even before the lawsuit, that this could happen. And it's very minimal, the amount of buyers that are non-represented. It's probably in the teens, is what we're seeing in like Big Sky Country MLS when it shows who's non-represented. Couldn't that be better serving to have that in the relationships in real estate, to explain a non-represented buyer cannot get paid a compensation because they're non-licensed? I think it raises so many questions on how we get paid that it's going to confuse a seller when we're doing a listing agreement. I just feel that's too much.
Well, in the listing contract, Jennifer, and you know, I don't want you to feel like I'm being critical, but we're always open to suggestions. But in the listing contract, the only reference to an unrepresented buyer is if you, as the listing agent, are saying to your client, I want to be paid more money if it's in the teens, right? If there's an unrepresented buyer on the other side, that's the only thing we've added to the listing contract on unrepresented buyers.
But it creates a question for we're trying to do a job, and my value is what I charge. And so for then a seller, me to have to answer to a seller if they say, well, if you're not representing that buyer, let's cut my commission in half. I mean, those are going to create questions that are going to be hard for an average agent to answer because they're nervous
where you're
enough
coming
doing
from,
a
Jennifer.
listing presentation.
Yeah,
I
I see a different perspective. I look at when we're going through the listing agreement, I just look at it as a different perspective. I find it a great opportunity when we reach that point to be able to discuss at that point what a transaction would look like with an unrepresented buyer, and it opens it up for discussion at that point with a seller. So I look at it as kind of an opportunity to have a discussion, and it's a bullet point there where if this is in the realm, because I have had discussions about unrepresented buyer, and the seller, one of the sellers said, Angela, I have absolutely zero interest in dealing with, I mean, it opened the discussion where the seller then gave the opportunity to give me his thoughts regarding that. And I felt it was a good opportunity because it is a possibility, while minor, it's a possibility, and it just made my listing presentation more thorough of what could happen.
But I would say this, Jennifer. I mean, the changes we made, we may walk some of them back. This is, as Robin has said before, these are test drives, and they may not all work. So, I encourage you and everyone, if there's some things, I mean, you might have things that we should add to the forms. You might be saying, this is a horrible idea, take this out. Submit. Yeah, I understand, and it comes multiple, but what would be very helpful is, and I know you didn't say this, but the form sucks. That's not very helpful for us. So if you say something like, hey, I think you should reconsider including this language at lines 10 to 30, that's helpful. Yeah, but submit it in writing so we get it on the agenda, and through the portal, it's on the MAR website.
Yeah, and I would just kind of say that the breakdown of that compensation and listing agreement is something that has been requested and discussed at the Forms Committee multiple times over the last several years, even before the settlement. And for every kind of comment I've heard similar to that, because Jennifer, to be perfectly honest, I've been one of the people on the Forms Committee that has held my hand back on that and said this is a business practice. We've also heard, I don't know, this is going in and out. We've also heard from people who say, well, we're not being transparent, we need to break this up. So we're trying to balance all that, but this trend of a little bit more transparency is something we're seeing kind of across the nation in forms, and we certainly, if it is harming agents, we want to hear about it.
Over here, Jim.
Test.
Here. Correct.
That's correct, Jim. Yeah. I'll repeat the question. I'll repeat the question, Jim, for those live streaming. The question was just confirming you cannot withdraw an inspection notice after the inspection date. And the inspection date, again, is the first date if you're looking under the inspection contingency.
Well, and just to provide some clarification, that is exactly, you can't withdraw an inspection notice after the notice date and terminate, but you can withdraw the inspection notice after the notice date and go forward, releasing all contingencies.
Yep.
So read the forms, read them.
Hi, Brittany Hunter. I just have a quick, because I'm looking at the listing agreement, under the compensation payable to broker, just some words maybe as a suggestion, just because I see they're missing on the new form compared to the old form. You know, when it says that very top line, I use that a lot. Broker is employed to find a buyer ready and willing to acquire the property at the price and terms stated above, or as such price terms as seller accepts. I really like that, just because now it just looks like on line 38, hey, the percentage, and I understand that you guys are trying to shorten it because it's become a long document, but full sales price. It's nice to see that language, because then the seller understands they do have the right to accept what terms. We're asking for this on X, but it's just, so there's just one of those. The other one, and maybe
Okay,
I've missed it.
Brittany?
Yes, sir.
Submit this in.
Okay,
Yeah,
okay.
because I can
That's
guarantee you,
fine.
I don't know about these two, but I'll forget this in 5 minutes.
That's fine. I have a couple, so.
Yeah, please submit it in writing, Brittany, because Jamie can't rely on Mike and I. We will too forget.
What are we talking about?
I don't want to cut Brittany short, so I want to hear her out, but I think, you know, given that it's 12:37, I think this time would be better served for questions, and if you have form modification suggestions, get into them to us either by emailing me, emailing Nicole, or using the web portal. But go ahead, Brittany, if you have some other stuff. I don't want to cut you short.
You may have hit on this, Jamie.
Over here
You're over
first.
here first, yep.
I think mine might solar panel addendum. Did you give any consideration to the definition of solar energy system? Because there's 3 different types, and Jamie should know what I'm referencing.
Yeah, we did, and decided to kind of go with simplicity and say, well, if it's on your roof and it gathers sunlight, then that's good. I'm being facetious a little bit, but it gets pretty into the weeds and pretty complicated. I'm not sure at the end, Jim, it made a difference. But again, if there's some things about the different types of systems, which I am aware exist, that you think need to be incorporated in the form, we'd love to hear it, especially with this being a brand new form.
Yeah, you may have answered it earlier, but let's say, for example, somebody goes along with a buyer. They're not a buyer, they're a parent, boyfriend, girlfriend. They're signing a form, or they have to sign a form, or?
Nope, in fact, that's right under the part where we inserted language to say associates of mine can show property on my behalf. We also added a space for for the, people are cutting me off here. We also added space on that bio rep to list like dad and mom.
And I'll say this, Craig, I think, so the additional names to insert under the biorepresentation agreement are kind of like stand-ins, avatars, for lack of a better word, like where you're not going to be there as the buyer, but this person is in your absence. If you're like, if you're going to represent me and I'm like, hey, I want to bring my daughter along with me, I don't think you need to add them, right?
Maybe just to clarify too on that, if you were asking like in addition to, there's additional people touring as well. I guess the main focus would be who's the buyer.
Yeah.
Yeah. Sorry, who's going to be on the contract? Sorry, I didn't.
We'll repeat the question. How's that? We'll repeat it.
Line 101.
Which document?
Okay.
So starting up at 91, if we check the box, buyer agent compensation payable by seller, and then under that you have options. Broker is authorized to communicate that seller is willing to pay compensation to buyer agent in the amount of whatever. And the next box at that level is broker is not authorized to communicate that seller is willing to pay seller to buyer agent compensation. Our question is that supposed to say to communicate the amount that seller is willing to pay? Because I can't see how that plays out in reality if someone calls me and says, hey, are you or the seller offering the buyer agent compensation? And I can't answer that question.
Yeah, so the question is in line 101 is where it says broker is not authorized to communicate that seller is willing to pay compensation. Should it instead say the broker is not authorized to communicate the amount that seller is willing to pay? That's actually a really good idea. And the intent here was to address situations where the seller is willing to pay compensation. They don't really know how much they want to pay, and they want to decide how much they're going to pay depending upon the strengths of the offers they're going to receive, and therefore they don't want any communication out there that says, I'm willing to pay X% or whatever the case may be. So, yeah, bring me your offer. My seller may be willing to offer compensation, the amount of which is to be determined. I think that's a really good suggestion, and again, just because I'm old, put it in the portal.
If you email me, you're the second person that's asked me about that in 2 days. So if you send me an email, we'll get that on there.
Over here.
Awesome. I just have a question on the touring agreement. Is it line, I don't have it right in front of me, but line 24 says pretty clearly in there that you're only there to consult on those properties. But we also have to have the relationships agreement form signed that says we're solely acting in their best interest and all of these things that we're doing just as representation. Is it contradictory? Like, do we need an additional something?
I don't think it's contradictory in the sense that you cannot do anything under your license unless you disclose relationships.
Yeah, and I think, Jenny, your question is, well, does the relationship form work given that the limited service buyer representation agreement under which you are providing much more limited services? And the answer is no, right? The duties imposed upon you as a real estate agent representing a seller or a buyer are going to be the same, and the duties don't address the level of service, right? Got to act in the best interest of your buyer, got to disclose adverse material facts, things like that. That's not going to change whether you're providing the full array of services or whether you're just doing a tour and showing.
Okay, so second part then, on the settlement, does it state that compensation has to be disclosed prior to showing? I can't find it anywhere on NAR's facts that it has to be in there or not in the program.
The BRA must be executed before a showing. The BRA must include, I can't remember the language, but language that specifies, either clearly sets forth or the amount of compensation or the method by which the compensation will be calculated. So, step one is you got to have a BRA before showing. Step two is the BRA must include these things. Therefore, the compensation must be specified before showing.
And so the touring agreement is basically saying, I'm doing this specific thing for you, I will show you this house, and you're basically saying, I'm doing it for nothing. So my compensation to show you the house is nothing.
Right, your compensation is being disclosed because there isn't any.
Yeah. And thanks for reading the settlement.
Nicole, over here, Hattie.
So I'm the listing agent on a property, and an unrepresented buyer comes to me, wants to make an offer on the property. What's the appropriate way to handle that using our buy-sell if they're unrepresented?
We'll let the attorney tell you the best practice.
Yeah, and I'll tell you the legal best practice, and then, Mike and Angela can let me know if there's some fill-ins there. But, so number one, your license, so MAR owns a copyright on all forms. The license you have as a member of MAR to use the forms includes situations in which you're involved in the transaction. So if you're buying a house yourself, you can use the forms. If you're representing a seller and the buyer is unrepresented, you can use the forms. So use of the forms is not an issue in any transaction. What you can't do is you just can't say, if your neighbor comes over and says, hey, Hattie, I'm selling my house to my cousin, give me your forms, and that's all you need to do. You can't do that because you're not involved. After that, exactly, then it gets I don't want to say murky and gray, but, you kind of have to balance the somewhat conflicting, perhaps, interest between making certain that you're providing representation to your seller, not killing the deal because the buyer's not represented, but not going so far in the other direction that you're engaging in conduct which would create an agency relationship with the buyer. So, for example, the buyer said, you might send over the blank buy-sell agreement and say, you need to go through this and fill it in, or you need to go through this and tell me what you want. Email me the substantive terms that you want to fill in. They call you up and say, well, Hattie, how much should I offer? Or should I get a home inspection done? Should I elect a financing contingency? Those are the kind of things that probably rise to the level of representation. But I don't want anybody to walk out of this and say, here's the buy-sell agreement, don't ever call me again, make your best offer. Like, you can be a little bit more user-friendly than that because you're acting in the best interest of your seller.
Yeah, and well, I'm going to add a little bit to that. It gets a little complicated because there's, business practices and people do things different ways. I think the more you are communicating with them while filling out a buy-sell, the riskier you are walking the line of some sort of agency or representation unintentionally. My preferred way to do it, and again, there's not one right way to do this, is like if you are an unrepresented buyer who wants to write an offer on one of my listings, I've obviously met you at the house and walked you through it because I'm working on behalf of my seller. And what I usually do is say, hey, send me an email with what you want your offer to be, what you want any other conditions and all that. And I will discuss it with my client, and we will either put that on a contract and send it back to you, or we'll just reject it. And in that situation, I then use the buy-sell as basically a reverse buy-sell. It's like a counteroffer, except I don't like to say counteroffer because it confuses people. But you just take what they sent you, and then you are working on behalf of your client to put that onto our forms, and then if they left something out, you fill it in after discussing with your client, and you send it back to them. And if they sign it, you have a contract.
And I also prefer,
Yeah, but if they sent it to you in an email, you've got a nice little trail of like, here's my first offer to you. It's like a letter of intent almost. Yeah, so you use it as reverse.
And the buy-sell doesn't, that's how it's structured, but there's no legal requirement that it come from the buyer. And, if I don't want to spend too much time on this, but, if that happens, I think everything Mike said, I agree with 100%. But if that happens, or your seller's like, I'm not agreeable to these 5 things that the seller wants, well, when you email it back to the buyer, just call it out. Say, hey, talk to my seller, and no, they're not willing to accept that price, but so I put in this price. Take a look, let me know what you think.
and I also agree with Mike's idea of, for lack of better terms, the reverse presentation of an offer. I think it works very well. The only other thing I would just add to that is be very careful as far as how much you engage in conversation, what you engage in, as we have seen offices be taken to task on just overstepping communication.
Yeah, I mean, if they ask kind of like why, well, it's like, this is what my seller wants. or, my seller thinks that inspection window is too long. Not like, oh, the norm is this,
Right here. Okay.
We'll repeat it.
On the statement of non-foreign status on line 3 with the social security number, this is a threefold question. So if a seller is private, can we put language in there stating to be verified at title?
Yeah, so the question is on the statement of non-foreign status where the blank is for the insertion of a tax ID number or a social security number, can you just fill it in and say to be provided a title? Yeah, I think that would work. In fact, one of the options would
Do
be
that all the time.
just to send the form and have it executed at title instead of advance, so that again, the thing we're trying to get away from is emailing or even having to save a form that has either your client's or the customer on the other side's confidential, social security number.
Yeah, real quick, just add to that, because I think what you just said is exactly what I'm doing. I'm not filling in that. And it's like, if you write in there to be verified at title, you're saying, we'll do this. But if you're a buyer's agent, a good thing to do is just when escrow's open, the first communication you have with the title company, send this blank form to them. Just like Jamie said, will you have this executed closing? Because then you're doing it, you've got a paper trail, but we are not sharing social security numbers and stuff like that.
Okay, so that was the second. Yeah. She said it's nice to know before closing that.
Which is, whereas listing agents, we need to do our job,
Yeah.
and we should find that out.
So you answered question number 2. 3 is to get a copy back at title that's been redacted. Does that, for our records, because we're required to have it, but is it twofold?
You're not required to have it.
Okay, so not mandatory in the state of Montana.
No, it's a federal law.
Yeah, I think in that situation, if this whole thing came up and it turns out that the seller lied on it, and so the buyer's like, well, we verified it, we're going to be able to point to the title company and say, we asked them to do this, they have a copy in their file. Like, I think that there's a lot of steps there.
But I mean, if office policies require that you have all documents in your file, then yes, I would redact it. I mean, this is what we have a very secure database management system for our law firm, and we either do not take social security numbers and save them up to our system, which is on the cloud, or we redact. We don't want the risk, because you get somebody who hacks into your system, even if they don't get anything, the process you have to go through if you've accumulated private financial information from any of your clients is horrible. In fact, it can cost like $40,000, $50,000 just to go through it.
Hey, buyer representation agreement in the authorization section might be in the weeds a bit, but are we required to add supervising broker into those authorized users? A consumer might not understand that that's part of the relationship. Is that necessary?
I would say no, and Jamie's shaking his head no.
Yeah.
Great.
No.
There's, the question was, do you, in that listing agreement or in the buyer rep agreement where you're listing other people, do you need to add supervising broker because the client might not be aware of that relationship? And the answer to that is no.
Yeah, and interestingly enough, in the state of Montana, the only thing that a supervising broker must sign is a listing contract.
Yeah,
Whether or not they may change that and require signatures on BRAs, given the complexity of BRAs due to the settlement and the practice changes, is TBD.
Like a lot of things in Montana law, a lot of the rest of how we handle supervision and how that role kind of relates to each other is just practice over time.
I guess just to clarify, a supervising broker can step in at any point on behalf of that agent.
Yes, a supervising broker could step in at any time on behalf of an agent who is assigned a buyer rep. And it doesn't need to be on there because the explanation would be given, I am Jim's supervising broker, he's out of town, or whatever.
Okay, so here's my biggest question is, which buyer representation agreement do you actually use? Because here we go, okay? So I sign buyer representation agreement with my client to open door A. Door A is not what they like, but then we look at 20 doors. and then all of a sudden now 20 doors has turned into 5 because they go back. Are we supposed to switch over to buyer representation agreement to seller paid? Because now 3 of those doors have compensation, but 2 don't. Like, which one's the primary? I mean, are we supposed to be signing both of them?
I would tell you that the primary is the one that's simply titled buyer representation agreement.
Okay.
The other ones are really created for specific situations, like touring, or like, hey, I am showing this one property and we know what the compensation being offered is, so we're gonna write it onto this. But if you're looking for, like, I want to sign one buyer rep and have it work for the whole transaction, it's the buyer representation agreement.
But if
The
you
original
don't know
one.
that your buyer wants to, I mean, they might want to look at that one specific address, and they don't know they want to make an offer, just as long as you have the buyer representation agreement.
But if you have the buyer representation agreement that specifies what you are charging, what your fee is, and it's on there, then you have met the terms of the settlement and you are covered.
So really, the buyer representation agreement, seller paid concession is very rare because you will know specifically when to use that form.
So here would be an example, Brittany. Let's say my buyer went through your open house, and they come back and they say, Angela, I want Brittany's house, let's make an offer on that house right now. And I call you up and ask if there is compensation offered, you identify compensations offered. I could make it specific for your one house that they've previously identified.
Yeah, I mean, to maybe try to simplify things, I would not use, and this is a test drive as well, but I would not use the seller paid compensation BRA unless the property or properties that the buyer is interested in making an offer in, all of them are offering compensation.
Because that's what they're telling you. They cannot afford a property unless they are able to have compensation paid for.
No, so that is not what this form was created for. So the question, I'll just repeat it, was if they are telling you they cannot afford a property that's not offering sellers compensation, that's not what this form is created for, because that's a situation where you really just have to case by case have that conversation. And we haven't created a form that specifically addresses that because we're concerned, to be perfectly honest, that buyer's agents are going to put themselves in situations where they're unintentionally committed to working for free.
No more questions?
Are there not any more? Julie, Nicole, not any more questions? One thing, so Jim Anderson doesn't get mad at me, that I just want to mention real quick. So the legislative reception is tonight at 6 o'clock on the table outside in the registration area, right, Jim? And Jim has some, our talking points of some key legislation points. So if you will be attending the legislative reception and you're going to be having a conversation with your elected representatives, it would be a good idea to brush up on some of these. And Jim has copies for you, and there's more available on the table. Anything else?
I just feel bad because I told Government Affairs Chair John that we wouldn't have time to talk about that, and
We're not going
We
to
have
talk
2
about
minutes
what's
left.
in them, but I just wanted to mention to people to pick that up so you're educated and have something to talk about tonight. And if that's it, thank you. Like I said, the last thing I'll leave everybody with is, you know, we're still in the challenging times, and, you know, I'm hoping we're not going to make another round of wholesale changes, but, you know, give it some time. I'm optimistic that the form changes that we've made are going to take some getting used to, but they're going to be better in the long run for not only our clients, but the membership as well. But that said, we're open to suggestions, and thank you for all your questions.
yep, and I would just say send the stuff if you want us to talk about it, because it might be something we haven't even considered.